Today's story starts from the year 2021. Location, Uttar Pradesh's Kasganj. A woman was walking back to her village with her 11-year-old daughter. Two men stopped by. They offered to drop the woman's daughter home on a motorcycle. The men were from the same village as the mother and they knew the family. And so the mother agreed. Later, the 11-year-old girl was taken to an isolated spot. One of the men allegedly grabbed the minor's breasts. The other tore the strings of her pajamas while dragging her under a culvert. The girl screamed. Two people who were passing by on a tractor heard the screams of her daughter and then reached the spot. The two men then fled the spot. Last week, this matter reached the High Court of Allahabad. What the judge said in the ruling triggered a massive outrage. The Allahabad High Court said that grabbing a girl's breasts or tearing the strings of her pajamas does not constitute rape or attempt to rape. The court instead said that the actions of the men constituted to aggravated sexual assault. Several top lawyers, activists called for the Supreme Court's intervention in this matter. Even India's Women and Child Development Minister Annapurna Devi weighed in on the High Court's ruling. Devi said she completely disagrees with what the court said, adding that the court's comments would send out a wrong message. Many expressed disgust and questioned that if the act that these men committed was not attempt to rape, what was it? And was it enough to just be categorized as an aggravated sexual assault? Today, the Supreme Court did step in and had some strong comments on the ruling by the Allahabad High Court. Hello and welcome, I'm Shubham Chauhan. Let's get started. Yesterday, the Supreme Court of India took suo motu cognizance of this ruling by the Allahabad High Court in the girl's case. This shocking ruling by the Allahabad High Court was brought to the notice of Chief Justice of India, Sanjeev Khanna, by an organization called We the Women of India. Today, the Apex Court ordered a stay or a pause on that verdict by the High Court. A bench of Justices B.R. Gavai and Augustine George Massey said it was pained to see some observations made in the ruling. The Supreme Court said that the ruling depicts a total lack of sensitivity on the part of the Allahabad High Court judge who has authored this judgment. That is Justice Ram Manohar Narayan Mishra of the Allahabad High Court, the judge in question who gave this verdict. The bench of the Supreme Court said that since the Allahabad High Court's observations are totally unknown to the tenets of law and depict total insensitivity and inhuman approach, we as in the Supreme Court, is inclined to stay these rulings, this verdict by the High Court. In fact, the Apex Court did not stop there. The court said it wasn't as if that the verdict was dictated at the spur of a moment by the High Court judge itself. It noted that the High Court had reserved its verdict in the matter in November last year, and after almost 4 months, the judgment was given. This meant that the judge of the High Court had given the verdict after a clear application of his mind. The top court also issued notices to the centre, Uttar Pradesh government, and the parties in the matter before the High Court. It has also sought, that is the Supreme Court has also sought the assistance of Solicitor General Tushar Mehta in the matter. During the hearing today, Solicitor General Tushar Mehta, who basically represents the central government, said he takes serious exception to the High Court's decision. Mehta said that the Chief Justice of the High Court was the master of the roster there, and it would be advisable that some steps are taken with regards to this case. Justice B.R. Gavai of the Supreme Court said, it is a serious matter. Total insensitiveness on part of the judge. This was at the stage of issuing summons. We are sorry to use such harsh words against the judge. The Apex Court bench was directed the High Court registrar to place its order immediately before the Chief Justice of the Allahabad High Court. The Supreme Court has also requested the High Court's Chief Justice to look into the matter and take such steps as he deems proper. So that was the latest update on the matter. But let's look at the facts of the case and the reasoning that the Allahabad High Court judge gave for this rather bizarre ruling. Once this horrifying act came to the victim's mother notice, she also had to fight to get her complaint registered in this matter. She had to fight even for getting a complaint registered. First, the victim's mother complained to the father of one of the accused. That man, the father, apparently threatened to kill her when she brought this matter up. The victim's mother approached the local police in Kasganj the next day, but again, the police also refused to take any action. No action was taken in that regard. Eventually, a local court in Kasganj treated the woman's application as a complaint and ordered the local police to file a case in 2022. During the hearing, the court summoned the two youngsters in this case, Akash and Pawan, under charges of rape and Section 18 of the POCSO Act that talks about attempting to commit an offense. POCSO is basically protection of children from sexual offenses. This act is used in cases involving minors. Even the father who allegedly threatened the victim's mother was summoned by the court. The three men then approached the Allahabad High Court, challenging the summons under POCSO. Their lawyer argued that this was a false case that was stemming from pure vendetta on part of the victim's mother. Eventually, after hearing all arguments, Justice Ram Manohar Narayan Mishra came to the conclusion we just told you about. Now, the judge's logic of not categorizing this as rape or attempt to rape was this. But here's what he said, I'm quoting from the order. An attempt to commit rape must go beyond the stage of preparation. An actual attempt to commit an offense consists chiefly in the greater degree of determination. The specific allegation against Akash is that he tried to drag the victim beneath the culvert and broke the string of her pajama. It is also not stated by witnesses that due to this act of the accused, the victim got naked or got undressed. There is no allegation that accused tried to commit penetrative sexual assault against the victim. So effectively, one interpretation of the judge's argument is that this breaking the string of the pajama was just preparation. That's what he called it in the order. Hence, it cannot be called rape or even attempt to rape. For an offense to be classified as the same, there has to be more than just that. The judge also says that witnesses haven't said that because of the act committed by these two men, the victim was naked or undressed. And hence, the Allahabad High Court, the judge of the Allahabad High Court came to the conclusion that the allegations leveled against the accused barely qualified as an offense of attempt to rape. Again, this is a High Court judge we are talking about. A judge who believes that grabbing a woman's breasts or breaking the string of a pajama is not enough to constitute even attempt to rape. Instead, it qualifies as sexual assault, a lesser charge in terms of the heinous nature of the law. Fortunately, better sense has prevailed in the Supreme Court. Meanwhile, the victim's mother has also moved an appeal against the High Court order in the Apex Court. That has been tagged along with the Suomoto case, that the Supreme Court has already begun hearing today. And this case would be heard in the Supreme Court again after 2 weeks. That's all we have for this report. Do like and share this video, comment and let us know what your views are. And of course, subscribe to HW News English on YouTube for more such videos. Thanks for watching.